let me tell you about a not unusual, I can't say it's common, but it's a not unusual fiasco that occurs regarding mineral rights, regarding a property. So, one version of the story. Seller has property that they want to sell. This property is in an area where there is oil and gas drilling activity, fracking activity. The oil and gas rights, the mineral rights, are valuable, and the seller does not want to convey away their mineral rights. The seller wants to convey the property. If you want to picture a property, imagine like a 10-acre gentleman's farm kind of property. They want to convey the property and keep, the jargon is reserve the mineral interest. Now, this video is not intended to tell you everything you want to know about mineral rights. It is not. All it is intended to do is identify two not unusual mistakes that are made regarding mineral rights. So, continuing with this story. This listing broker in this story was very experienced in the area, knew exactly what needed to be done, was conscientious enough so that in taking the listing, the legal description described the property reserving unto the seller the mineral rights. Fantastic. The property is put in the MLS and is marketed. The flyer boxes, all marketing of the property indicates that the seller will be keeping the mineral rights. An offer comes in. The offer makes no mention of the mineral rights. The listing broker is savvy enough to know that minerals, unlike water rights, by the way, mineral rights run with the land. Mineral rights run with the land. And so the listing broker knows that it's necessary to counter the offer with a counter proposal that's saying that the property will be conveyed with the minerals reserved in the seller. The seller is keeping the minerals. That counter proposal is accepted by the buyer. But then, human error comes into play every once in a while, and somehow the deed preparer in this transaction, the closer, the title company, paid attention to the legal description in the initial offer, but not in the counter proposal, did not see that the minerals were supposed to be reserved into the seller, and a deed gets prepared without a mineral reservation. The listing broker, who was conscientious enough to put this in the listing, conscientious enough to notice that the offer did not contain a reservation of minerals for the seller, conscientious enough to address it properly in the counter proposal, did not notice that the deed was prepared incorrectly, and the transaction closed with the property being conveyed to the buyer with the mineral rights. Big boo-boo. Big boo-boo. So you got to dial into all of those things. You got to A, find out what your seller's intentions are. B, the listing should be prepared consistently with that. 3, the property the property should be marketed so that to decrease the likelihood that you even need to make the counter proposal. It should be marketed as sellers will be keeping the minerals. Number 4, you got to pay attention to how the offers are worded. Number 5, if they're worded incorrectly, you need to have a counter proposal getting it right. And then number 6, don't assume that the title company is always preparing the deed correctly. Humans can make mistakes. You're supposed to be a double check on that. Look to see that the deed is prepared correctly. Let me also add in that if the transaction closes wrong, it's not the worst problem in the world to fix. Lawyers get involved. It can be ugly. But if the problem is discovered while the buyer still owns the property, it's easier to fix. That is, if your client is A and your client is conveyed to B, and the problem is discovered while B still owns it, it's much easier to fix than if B has conveyed the property to C, because in that scenario, C is completely innocent in that scenario. Okay, that's one thing. Remember those 6 steps that I just walked you through. There is another concept that brokers should know. And again, remember, this is not a class in everything you need to know about mineral rights. Take that class from my partner, Zach Gray. By the way, the denouement to the story I just told you, or at least one of the stories I told you, is that my law firm handled the malpractice defense of that case for the listing broker. The attorney who handled that was my partner, Cindy Manzano, who, after doing some title research, learned that the seller did not have the minerals to convey anyway, so that they were not harmed. But nevertheless, there are other cases where the seller did have the minerals to convey, and it got bollocksed up. Watch for that. But here's another thing that happens. Brokers will submit offers on your listings that might have a provision in it that says something like this: seller will convey all minerals regarding the property. Well, you want to counter out that clause when you're the listing broker. And there's two reasons you want to counter out the clause. One of them is it's completely unnecessary. Minerals run with the land. Yes, the gist of the generic deed is that the seller will convey all minerals, at least that the seller has to convey. They will automatically be conveyed by the deed. It's unnecessary. But is it bad? Yes, it is bad. Because if the contract says your sellers will convey all minerals associated with the property, your sellers may not have them to convey. Your sellers may not own the mineral rights, and you have allowed your seller to enter into a contract in which your seller is obligated to convey more than the seller has. And some buyers will be disappointed and choose to walk, and you go, phew, and breathe a huge sigh of relief. But some buyers will say, no, you breached the contract. You contracted to sell me all the minerals, and I am suffering because of your damages, and go after your seller for the damages that the buyer has by not getting the property for the price that the buyer contracted for, together with the minerals. Be careful with minerals. They create problems, not just for experts, but also for people who dabble in it. Be humble. Remember, it's a complicated world. Be careful out there.